Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. So, we received an interesting inquiry here on our YouTube channel. This has to do with somebody who got accused of violating a restraining order. My brother punched his 17-year-old girlfriend. When she arrived at her home, the dad called the police. My brother was arrested. He was released on bail with a restraining order, but now they communicate through email. Well, wait a second. First of all, she's a 17-year-old girlfriend. How old is your brother? The reason is because if there's more than a 3-year age difference between the alleged victim and your brother is the adult, he could be charged with a felony, which would be a violation of Penal Code Section 261.5, having sex with a minor if there's evidence indicating that they've been having a sexual relationship. More likely, they have been having a sexual relationship, which is a felony that carries up to 3 years state prison. And may have to register as a sex offender under Penal Code Section 290 here in the state of California. Now, the other issue is the fact that obviously domestic violence, obviously I need to know if that's a misdemeanor or a felony. Under Penal Code Section 273.5, if there was any kind of traumatic condition on the face of the victim, that carries up to 4 years state prison, or any body part of the victim that carries up to 4 years state prison. If the victim did not suffer any kind of injury whatsoever, if we're talking about just a push or blowing smoke or throwing water on her, well then that would still be a misdemeanor domestic violence under Penal Code Section 243(E)(1), which is a misdemeanor that carries up to 1 year in county jail, plus having to take domestic violence classes once a week for 52 weeks a year. Now, but based on the fact that your brother was out on bail, there's a good bet that this was a felony domestic violence, obviously because of a punch here. Now, problem is they're communicating via email. Well, see, usually the first court date at the arraignment for a domestic violence case, a judge will issue a protective order, which is valid for 3 years, where the judge will say no communication whatsoever. No email, no text, no YouTube, no Facebook, no Instagram, none of that stuff, not even by way of a third party, aside from an attorney. Now, there are situations where the victim could be in court, the first court date, and could say, well, I want to stay with him, I want to keep the relationship going, so can I please have a modified order? But it's very, very doubtful. It's very, very doubtful that that happened in this situation. It's extremely doubtful that this happened in this situation. Okay? So if he's in fact violating this restraining order, that would be a violation of Penal Code Section 273.6 here in the state of California. That's a misdemeanor that carries up to 1 year in county jail, and more likely your bail, or your son's bail, is going to get, or your brother's bail, sorry, it's going to get revoked. His bail is going to get revoked, and he's going to get put back into custody. Whoever bailed him out is going to lose that money. The bail bonds company is going to get their money back because the bail will get exonerated, but more likely you yourself or whoever bailed him out, your brother, is going to lose that money, and he's going to have to fight both the violation of the restraining order as well as the domestic violence case while he's in custody, and there's a good bet that he's going to have to spend all of his time in custody until his case resolves. Regardless of that, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos. But if you've been accused of a crime and need representation in court, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. On our next video, we're going to be discussing the case of somebody who got accused of a robbery. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers, criminal attorney, criminal attorneys, DUI attorney, DUI attorney.